Stephanie Bracewell, and I decided to do my presentation on Chapter 11, Sexual Harassment. Harassment is a request for any kind of sexual favors, as well as touching, joking, commenting, distributing material of sexual nature. How do you know it's sexual harassment? The victimized employee must be a member of the protected class, gender-related, must not have consented to sexual advances, it must be based on sex, and the conduct complained of must have had a deleterious effect on the employee's job, and the harassment must have occurred during the scope of employment. Tort claims against the harasser. A victim can sue the offender personally under tort law in state court. If there was unpermitted touching, this gives rise to torts of civil assault and battery. If sexual comments were written or sexual pictorials were drawn, the suit would be for libel. If generic comments were made that degraded the gender, the individual could claim the tort of infliction or emotional distress. The majority of lawsuits are brought by women, but it definitely isn't uncommon for men to sue as well. Vicarious liability, it used to be known as quid pro quo. It renders the employers responsible for their supervisors' tangible employment actions. So basically, they cannot say that you need to have sex with me in order to keep your job. Tangible employment action involves situations in which a superior is demanding sexual favors in return for hiring, transfer, promotion, etc. A company must promptly investigate and take appropriate action if there is a complaint. An employee who has filed a complaint in accordance with the company's sexual harassment policy will forfeit his or her claim unless they can establish retaliation. Once an tangible employment action is established, the affirmative defense is no longer available and the employer is absolutely liable. An employee wishing to bring a sexual harassment complaint against an employer with fewer than 15 workers would have to consult local or state law. Person standard, it would be what sexual harassment would be as judged by a reasonable person. The damages are normally capped off at $300,000 as stated in the 1991 amendment of the Civil Rights Act. The work environment is intimidating and offensive sexual conduct perpetrated by a superior or coworker against an employee. The hostile action must be pervasive enough as to interfere with the employee's work. So if you feel as though you cannot get your job done, then it creates a hostile work environment. It's severe and pervasive. It's the alleged act of sexual harassment. It must be severe enough to create an abusive work environment and disrupt the victim's employment. If the work environment becomes intolerable because the employer refuses to remedy the situation and causing the victim to resign, then the victim can claim constructive discharge. But if the victim must resign because of the sexual harassment. If not, then constructive discharge will not apply. If the sexual harassment has no connection with work, then the employer is without merit. Model sexual harassment policy. These are just different kinds of definitions of what it is. The touching, joking, commenting, distributing of material of sexual nature, what a sexual advance is. This would help you as a company have in your sexual harassment policy saying, hey, this is what you need to know and this is what you don't do. These are the common emotional and physical reactions of sexual harassment. You can have poor concentration at work, fear and anxiety, there's a high staff turnover, increased absenteeism, there's a tarnished company reputation, there's legal and consultant cost, less teamwork, not just the victim. Options for action, say no clearly. Document your harassment, get emotional support, and document your work. Explore company channels and file a complaint. I chose to do Tanisha Ross Page versus the St. Louis Board of Police Commissioners. She claimed that her former supervisor created and distributed a wanted poster. She was a police officer. And so he said, as a little comment underneath the poster, subject was wanted for having the baddest body in the St. Louis area. And quote unquote, use extreme caution when approaching the subject. And then said he invited her to skinny dip in his hot tub, and she was married, and then even asked her to sit on his lap and removed her bullet-resistant vest so that he could get a better view of her body. And Etcher said that Gorey denied the accusations. After she filed the complaint about his behavior, he assigned her to unfavorable shifts, changed her performance reviews, and denied her time off. And then he reportedly told others that her complaint was frivolous and he wanted her transferred. She was a canine officer and was injured by a dog on the police force in 2012 and was permanently disabled. The jury ruled in her favor and awarded her $300,000 in compensatory damages and $7.2 million in punitive damages. And these are my works cited. Thank you.